Who runs Britain? No, I mean, who really runs Britain? Where are our laws decided upon? Is it here, in Parliament? Or is it here at Downing Street? Or is it here at the Supreme Court? Or is it here, hundreds of miles away, in Strasbourg, home of the European Court of Human Rights? In that building sit 46 judges. We never voted for them. We have no power over them. I'd be surprised if anybody could name even one of them. Yet they can tell our government what to do without the British people having any say at all. So what is the European Convention on Human Rights? Where did it come from? Who started it? And why does it control what we can and cannot do in Britain? Amid the ashes of the Second World War, democracies in Western Europe, victorious but weakened, looked east in fear. Communism gripped Eastern Europe. Our leaders wanted to enshrine personal liberty to stop authoritarianism spreading across the continent. At the Congress of Europe in 1948, politicians including Winston Churchill proposed a Charter of Human Rights and a new international court to enforce it. So the Council of Europe drafted a new European Convention on Human Rights and set up the European Court of Human Rights here in Strasbourg. Britain saw it as a way to promote liberty rooted in our own legal traditions, Magna Carta, habeas corpus, and an independent judiciary. At first, it was about resolving disputes between countries. Individuals couldn't bring cases in the court unless their governments allowed it, something Britain refused to do. In 1966, Harold Wilson changed all of that. He allowed individuals the ability to challenge British laws in Strasbourg. For the first time, the European Court could interfere directly with British laws. Parliamentary sovereignty, the foundation of our democracy, began to be weakened. The court invented the living instrument doctrine, allowing it to reinterpret the convention however it wanted, well beyond its original intent. Then came 1998. The Council of Europe made the court's decisions binding on member states. It was a quiet change, but a seismic shift in our democracy. It was a power grab. The court could now override governments and parliaments without any democratic scrutiny.
This is a radical reforming government. Sometimes the revolution is a quiet revolution, but a revolution nonetheless it is.
At the same time, their original scope. It turned our asylum system into a farce. We couldn't deport a murderer back to Zimbabwe because of his love child, Article 8. We couldn't deport a sex offender back to Sri Lanka because it turned out that he was gay, Article 3. We couldn't deport a rapist back to Nigeria because of his life here. You get the picture. Britain has become a soft touch. Parliament passed 3 laws to stop the boats and deport illegal arrivals to Rwanda. Yet as Home Secretary, I couldn't deport a single illegal arrival to Rwanda because of the convention. And we couldn't do anything about it. It gets worse. Why do the police seem so powerless against militant protesters? Just Stop Oil blocking roads, Extinction Rebellion halting the traffic. It's because of warped interpretations of Articles 10 and 11, the freedom of expression and assembly. Judges here in Strasbourg ruled that it's okay to commit criminal damage in the name of human rights. Remember the Colston statue case? BLM rioters pulled it down. But they were acquitted because their human rights mattered more than yours. As Attorney General, I was able to fix part of the problem, but only after years of legal chaos. And our lives get worse because of the convention.
Now! Maybe that car! Now!
Freedom fighters! And finish you all off!
But this isn't just about protests or immigration. This is about national security, because the convention is being used to persecute some of the bravest people who keep us safe, our soldiers. For years, here in Northern Ireland, our armed forces fought to keep the peace. Yet in 1995, the European Court of Human Rights ruled that British soldiers who thwarted a planned terror attack had violated the rights of IRA terrorists. Here in Belfast in 1972, British soldiers killed an IRA terrorist. It was the height of the Troubles and they were acting lawfully. Yet decades later, as retired veterans, those same soldiers were prosecuted for murder. One of those soldiers has been under investigation 5 times. He's been hounded through the courts and his life has been turned upside down because of Article 2 of the Convention. What's worse, in 2001, the European Court of Human Rights ruled that IRA terrorists deserved compensation. That's the same IRA that killed innocent people and devastated communities throughout our country. The truth is that under the Convention, the rights of IRA terrorists have become more important than the rights of British soldiers. How can we expect our soldiers to put their lives on the line when we can't even protect them from lawfare? The Northern Ireland Assembly, here at Stormont, is an integral part of our United Kingdom. It was created by the Belfast Good Friday Agreement, which has been the foundation of peace for over 2 decades. Now, the European Convention of Human Rights is mentioned in the Belfast Good Friday Agreement. Some people say that's a reason why the UK can't leave the convention. Well, they would be wrong. Over the last few decades, the Belfast Good Friday Agreement has been changed, whether it's the Stormont House Agreement, the Hillsborough Castle Agreement, or the Windsor Framework, or many others. So many changes have been introduced into the original agreement. That's why we must rewrite the Belfast Good Friday Agreement and finally put the British people first. We do it by changing the Northern Ireland Act in Parliament. Now you might ask, why not reform the convention? Well, Tony Blair, David Cameron and Rishi Sunak all tried. They all failed. The convention cannot be reformed. We've run out of options. The truth is that we may well have left the European Parliament, but we are still governed by the European Court. Some people say we should repeal the Human Rights Act, but remain in the convention. That solution won't work. The British people deserve honesty, because as long as we are tied to the European Court of Human Rights, the United Kingdom does not control its laws. The convention is undermining our democracy and our sovereignty. It's become something far removed from what Britain originally signed up to. Countries like New Zealand, Australia and Canada protect their rights just fine without it. So now is the time to leave. No more foreign judges deciding against the safety of British children. No more vexatious prosecutions of our brave soldiers. No more open borders. Now, leaving won't be easy, but it's the right thing to do. Here's how. First, we trigger Article 58, the exit clause, giving 6 months' notice to the Council of Europe. Next, we prepare our laws to take back control. We repeal the Human Rights Act and we reform judicial review to curb activist judges. We amend the Wales Act and the Scotland Act, and we change the Northern Ireland Act to rewrite the Belfast Good Friday Agreement so that laws are applied consistently throughout the United Kingdom. And we change the terms contained in our trade agreement with the EU. All of this is possible with the right political will. What about civil liberties? Well, our rights didn't start with the Convention, nor will they end when we leave. The right to a fair trial goes back to Magna Carta. The right to life wasn't created by Article 2. It's been protected by the Offences Against the Persons Act 1861 and the common law. Torture has been illegal in this country since the 17th century. The Police and Criminal Evidence Act of 1984 protects us against unlawful detention. You see, the English legal system is one of the most sophisticated around the world and emulated globally. But most importantly, our laws should be made by your elected representatives who are accountable to Parliament, and Parliament must be accountable to you. That is how our country should be run. By you, for you. That is democracy.